judgments in the appeal: O'Neill against Her Majesty's Advocate and Lauchlan against Her Majesty's Advocate.
On the 10th of June 2010, the appellants were found guilty in the High Court of Justiciary at Glasgow of the murder of Mrs. Alison McGarrigle in 1997 and of a subsequent attempt to defeat the ends of justice by disposing of her body in the sea. They were sentenced to life imprisonment. In a separate trial held immediately before their trial for the murder, the appellants were found guilty of a series of sexual offences relating to children. Both trials took place in front of the same judge, Lord Pentland, but with different juries. Mrs. McGarrigle was last seen on the 21st of June, 1997. There had been a drinking session the previous day at which she and the appellants and a number of others had been present. She was never seen again, and no body was found. She was reported to the police as missing in February 1998. On the 17th of June 1998, the appellants were convicted of sexual offences, including offences against her son, Robert McGarrigle, and they were sentenced to 6 and 8 years imprisonment, respectively. In September 1998, while they were serving these sentences, the appellants were taken by the police for questioning on suspicion of conspiracy to murder Mrs. McGarrigle. They were asked by the officers whether they were involved in her murder, but they both remained silent. Owing to a lack of evidence at the time, the proceedings were not commenced against them, and they were not arrested or charged. It was not until 2005 that they were eventually charged and remanded in custody for this offence. After the verdict in the first trial, the Advocate Depute moved for sentence and handed the judge a list of the appellant's previous convictions, which included their convictions for the offences against Mrs. McGarrigle's son. The judge reserved sentencing for the sexual offences until after the trial for murder was completed. But he warned them that as they had been convicted of sexual offences, they were subject to notification requirements under the Sexual Offences Act 2003. He referred to their records and said that they were evil, determined, manipulative, and predatory paedophiles of the worst sort. Among the various issues which the appellants raised when they appealed against their conviction for murder were two that had brought the matter before this court. The first related to the interval between their interviews in 1998 and their being charged in 2005. It was suggested that there had been a breach of their right to a trial within a reasonable time in terms of Article 6.1 of the European Convention on Human Rights. The second related to the remarks by the trial judge at the end of the first trial. It was suggested that they indicated that he was apparently biased and that the act of the Lord Advocate in persevering with the murder trial before him was incompatible with their right under Article 6.1 to a trial before an impartial tribunal. These are compatibility issues within the meaning of the Scotland Act 2012. The court determines the compatibility issues as follows. First, the date when the reasonable time began for the purposes of the appellant's Article 6.1 convention right was 5th April 2005. And second, the Lord Advocate's Act in proceeding with the trial on the murder charge was not incompatible with the appellant's Article 6 right to a trial before a tribunal that was impartial. Article 6.1 provides that in the determination of any criminal charge against him, a person has the right to a fair trial within a reasonable time. Article 6.3c provides a right to legal assistance for anyone charged with a criminal offence. The focus of Article 6.3c is on the state of affairs when the suspect is first interrogated, as to wait until the stage is reached when he is being questioned without access to a lawyer could seriously prejudice his right to a fair trial. This is in contrast to the reasonable time guarantee in Article 6.1. It relates to the running of time, not on what is needed to preserve the right to a fair trial. The rationale is that the person should not remain too long in a state of uncertainty. Time runs from the date when the suspect's position is substantially affected by an official notification that he is likely to be prosecuted. These are separate guarantees, and they fall to be approached independently. The appellants were certainly not, at any stage of their interviews, charged in the formal sense. They were both asked directly whether they killed Mrs. McGarrigle, but in the context in which these questions were being put to them, it cannot be said that this amounted to an official notification that they were likely to be prosecuted. In the absence of any evidence to show where, when, and how she died, the police were in no position to initiate criminal proceedings at that stage. On the issue of apparent bias, it would only be if the judge expressed outspoken opinions about the appellant's character which were entirely gratuitous, and only if the occasion for making them was plainly outside the proper performance of his duties, that a fair-minded and informed observer would doubt his ability to perform those duties with an objective, judicial mind. The context indicates that nothing of that kind happened in this instance, in this case. No objection was made by the defence at any point to the fact that Lord Pentland was to preside over the murder trial as well, and there are no grounds for doubting his impartiality. The proceedings will, as the statute requires, be remitted to the High Court of Justiciary. The Court will now adjourn.